Welcome back. Today is probably going to be one of my shortest videos. Hopefully, we'll see how that goes. I just did a video yesterday of some recent court filings in Sarah Paulson's case. However, as soon as I posted it, the state decided to pop off and respond to a whole bunch of the motions that Ms. Paulson had submitted prior. So I just want to go through those and see what the state has to say. But first, I want to give a few warnings up top. One, I'm a talker. You'll be okay with that, or you won't. That's fine. And two, yes, I call her Sarah Catherine Paulson. That is her birth name. That is the name she was born with. That is the name I shall use. And I understand that there is some confusion because when you hear Sarah Catherine Paulson, people think about the critically acclaimed actor.
He's escaping! The killer is escaping! Help me!
Who is absolutely incredible, and I love her in every way. Then there is Sarah Catherine Paulson, a critically acclaimed murderess.
Do you need Jesus right now?
It's really creepy once you look at it that their names are the same, just spelled differently, foiled completely opposite. It's like good versus evil, but this is an American Horror Story, so it feels accurate. She is no longer married to Brian. That family and that name does not deserve to get dragged through the dirt and mud as it has been. The fact that that name is going to be associated with her face, like that family name, when she isn't even a part of that bloodline at all, is just like gross to me. So, and they're divorced, so there's no reason she should still have the name. I get it, you can keep it if you want. I don't know why she still wants to. If she changed her name, she could at least rebrand herself and say, oh yeah, when I had that name, that's when I was really bad. Now I'm going back to my original me, my pure self. There was no pure self. Although I heard she was on the game show, I haven't seen that. I don't think I'm emotionally prepared for that, but maybe I'll watch it while doing the interrogation video and put it in there. Who knows? But to recap what we covered in last video, it included Owens officially announcing their defense as the battered spouse defense because they got Julie Harper to sign on really quickly. I mean, they had 6 days to do it, so I do commend them for pulling it off like you did it. But now the state has things to say about it. But also, we found out that Owens is doing this pro bono, according to Sarah, because Sarah filed an affidavit that said he is doing this pro bono. So we will see how that goes. Anyway, that's in the past. Let's look at the present. I want to see what the state has to say. I hope it's a little spicy. We'll see. State's response to defendant's motion for statement of particulars. Comes now the state of Florida by and through this undersigned assistant state attorney and states and alleges as follows. 1. A statement of particulars is never required in Florida except in exceptional cases. Peel v. State. Appeal dismissed. Certiorari denied. There is nothing in the motion or in an affidavit that shows exceptional circumstances in this case requiring a statement of particulars. Damn. But I like this. I like that right off the top. He said, because Miss Paulson has this messed up. There is nothing in this case that has exceptional circumstances. You are just a global troll that has taken up a lot of attention. That does not equal exceptional circumstances that require all of this and all of that. You have gotten so many extra things purely because of the way you act, not because of the case facts themselves. They did not require this special treatment. If you put this entire case on a standard inmate defendant, whoever knows how to act with some damn sense, the case would have been long done. Could have gone to a speedy trial, done it in 60 days. Maybe. I mean, still would be life in prison, but you would have finished it. And you wouldn't have needed anything extra like we've been here for 4+ years. Wild work. But I'm glad that the state upfront is establishing There's nothing special about this, so I'm not going to pretend that there is. 2. Receiving a statement of particulars is not a legal right, but rather an act of judicial discretion. Miller v. State, period. 3. A statement of particulars is not necessary in this case for the following reasons. A. There is no variance in the information and the discovery as to the date, time, and places of the offenses. True. B. There is no variance in the information and the discovery as to the name of the victim. Double true. And C. The information filed tracks the statutory language in putting the defendant on notice of the law she is alleged to have violated. Yeah, because that statement of particulars, I can't remember what it said. I don't want to pull it back up, but it was basically saying that they didn't give her enough information, specific information to let her know what she was charged with. And I'm like, it's pretty clear. The victim was George Torres, who was murdered. He is dead. You filmed it, and we're charging you with murder for it. I mean, it can't get clearer than that. This whole case can be summed up in a thesis statement. That's how simple it is to understand, to conceptualize, and to prosecute. So, you don't need anything extra. And I like how it's like, all this extra stuff we have been giving you is not a legal right. It has been a nicety we have been affording you. So don't forget that. Wherefore, for the grounds above cited, the state of Florida respectfully moves this honorable court to deny the defendant's motion for statement of particulars. I certify that a copy hereof has been furnished to James Sullivan Owens, Dave Cacciatore. Nice job. This was perfectly spicy enough while completely professional. Actually, this wasn't even really spicy. This was just stating literal facts. So I'm glad you didn't shy away and try to save their feelings. And I know Mr. Cacciatore is not really the loudest in the courtroom or like the biggest personality in the courtroom. However, he gives me the vibe as someone, this is where he shines. Like he is the files kind of guy, like knows how to write what he needs to write and get the point across. And I'm starting to see that with this. And I feel like Mr. J is more of the trial lawyer who is a little spicier in the courtroom. I could be completely wrong, but that's just the vibe I got from their performances in past hearings. Moving on. State's response to defendant's demand for supplemental discovery. Comes now the state of Florida by and through this undersigned assistant state attorney and states as follows. 1. The state filed its response to notice of discovery on March 20th, 2020. Dang, they're saying we did this years ago. And just because we did it years ago does not mean we need to do it again. 2. Paragraph 5 of that pleading outlines the controlling law on this issue. 3. State v. Wright holds that the court must first inquire whether the information the defendant seeks is available if she would exercise due diligence. Nice. This is what I'm talking about. This is what I wanted to see. If you would have just tried, do a little diligence on your own. Did you even try to look for it yourself? Damn. 4. If the defendant were to exercise due diligence, she could easily obtain the information from the Orange County Sheriff's Office. Shots fired. Double homicide.
Yeah, double homicide.
Bitch.
Because absolutely, the stuff she was asking for sounded very simple and easy. And so that's why in my mind, I was like, okay, yeah, it's nothing for the state to just send that and give that back to them. But no. That is a lot of extra work for them. And the state does shit, right? They have a lot of cases. So if they start doing every little micro thing for every little other thing that's unnecessary, then they're going to have to start doing that for everyone. And then they'll get lost in the weeds and all of this and all of that. But it's way more beneficial to just say, do it on your own and ask me when you actually need me for something, not something you could Google search or request on your own. Really simply. Yeah. 5. Quote, the trial court should have first ascertained whether defendants could have obtained the requested criminal records from other sources through due diligence and determined whether the defendants had exerted their own efforts and resources and exhausted other available means to procure the information. State v. Coney. Exactly. Sarah has not exhausted anything but our time and patience. She has not exhausted any of her resources. She complains before she even uses them. She complained about the computer in that hearing, even though they told her at the beginning, we are giving you more time. And she still complained about not having enough time throughout the rest, not even acknowledging that they have extended that resource. You haven't used it yet, but you're complaining you still don't have it. Wait until you actually use the resources available to you, and then tell us you need more time above that, on top of that, or you need more X on top of that. This is basically just 5 points of saying you could have Googled this. You could have Googled this. 6, the defendant has attempted to obtain these records through the means available to her and failed. She has failed to state this in her motion. Oh, okay. So I guess they're acknowledging, well, no, they're meeting her halfway. Let's say what she says is true, that she has attempted, she's done absolutely everything. Nothing is going her way. Everyone is unfair. Everyone is judging her. It's the world. It's awful. She didn't write that down in the motion, though. She just said she wanted it. She didn't say that she couldn't get it. She didn't say she has not been able to get it. So, 7. Therefore, the defendant's demand for supplemental discovery should be denied. And true, absolutely. And we talked about this when she was pro se. Yes, it seems like things are a little harsh, but that is how law is. Law is not inferring your best intentions and then taking the best outcome for what you intend. It's what you actually do. So you didn't say you couldn't obtain the records through the means you have available. Even though you were pro se, we understand there was those barriers. You didn't say that. So we're not going to infer that or take any outside knowledge that you haven't put into this motion in order to argue with it. We can only argue with the facts you present before me. She did not present that fact, so denied. Correct. I certify that a copy hereof has been furnished to James Sullivan Owens, Dave Cacciatore, Jr. Next, state's response to defendant's second motion for additional discovery. Oh yeah, because there was 2. Oh, I started to read this, but it's literally the exact same thing. So the exact same thing for the first motion for supplemental discovery and for the additional motion. They said, see my prior email. So moving on again. State's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome, and state's motion in limine, and state's motion for examination by state expert. Okay. This one's a little spicier, a little more action-packed. Let's see what we got. Comes now, the state of Florida, by and through undersigned assistant state attorney, and states and alleges as follows. 1. On September 6, 2024, the defendant filed a notice of intent to rely on the defense of battered spouse syndrome. 2. Florida Rule of Criminal Procedure, requires the defendant to include, quote, a statement of particulars showing the nature of the defense the defendant expects to prove, end quote. See, you just asked for a statement of particulars from me. Why are you not giving us the same? I get it. They didn't have enough time to probably pull it off in their minds, but still, it's fair. You're going to bring it up. You need to put up. If you're going to bring it up, you need to put up. 3. The defendant's notice does not include any particular facts which, if produced at trial, would allow for Dr. Julie Harper to opine that the defendant suffered from battered spouse syndrome. Yeah, exactly. The notice, I'm still impressed that they got it in on time because they just had to get her to agree to it. But it just said, we attempt to use this defense and this doctor has signed on. They did not get to any particulars about the abuse or the claims of what she would be specifically examining in order to prove or to diagnose with battered spouse syndrome. 4. Therefore, the defendant's notice is legally insufficient and the court should strike the notice. Period. And I agree. Uh, Miss Paulson is no longer an esquire. She is no longer pro se. She has Mr. Owens as her law daddy to take care of her now. So the kid gloves are off. If you don't do it right, deny it. It's not up to par. I don't care. We only got 30 days left. Denied. And I think it will be. 5. Furthermore, the defendant only lists Dr. Julie Harper as a witness to show the defendant suffered from battered spouse syndrome. An expert witness cannot be used as a conduit to introduce inadmissible hearsay evidence, such as the defendant offering the defendant's hearsay statements. Florida statute, Therefore, the defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant testifies to underlying facts that would allow for her expert's testimony. Medina v. State, absolutely. Yes. So they're saying all you have is this doctor. You cannot put her on the stand and say, "Hi, I know she sounds like a lot. I know she's pretty violent, but there's a reason she's a battered spouse syndrome. Let me tell you why." No. Dr. Julie Harper can only be there to supplement and support the details and the evidence that comes out at trial, which would have to be through her testimony. So Sarah will 100% have to take the stand in order to use this defense, because she will have to say that I got beat so many times, I didn't know, I could not escape. This is the only way I could get out. Killing him, filming him, and laughing him was the only way I could possibly escape this abusive relationship that I kept him in. I mean, that I could not escape. So once she brings up those things, then Dr. Julie Harper can come up and say, "Hi, I know you just heard this testimony. Let me explain that a little more. I know these reactions seems a little bit erratic or a little bit uncommon or crazy or what have you, but here is my diagnosis, yada, yada, yada." And then she'll get torn apart on cross-examination, and it'll be as if she was not even there at all. I hope her career is just fine after this. I hope it is, but we'll see. 6. The defendant has previously provided statements to law enforcement. She sure did. I think she provided 8 statements at various times. There's no way she was ever going to win this case. It's enough for lawyers to combat one interrogation, but to have 8 different statements, every time you release a letter, you're releasing all new evidence and statements that are out there. It's just a mess. Yeah, so absolutely. The defendant has previously provided statements to law enforcement. Therein, she claims she accidentally left the victim in the suitcase overnight. Just reading that off a page still makes no sense. Accidentally left the victim in the suitcase overnight. Wild. Battered spouse syndrome testimony is not admissible if her defense is that killing the victim was an accident. Exactly, Wagner v. State, because battered spouse syndrome is an intentional killing. It is saying, I cannot escape my abuser. I am always in imminent fear of danger. I am always in fear of being attacked, and my only way out is to kill my abuser and run or to get away. You don't do it on accident. Completely directly contradicts. So let's say she's able to use this defense and they let her put it on the perfect way in her mind and get every single word out that she wants to get out. They literally can come back and say, but it can't be accidental. So she's going to have to admit that in all 8 of those prior statements, more realistically, they're going to point out maybe 2 or 3 of those prior statements to law enforcement. You have to say you lied constantly in every single one to every single officer for years about this incident, saying it was accidental and unintentional. And only now you are telling the truth and saying that actually I did do it intentionally. I mean, we know you were lying. We absolutely know you were lying. You did do this intentionally. So you are being truthful in that. But you are now saying, I did this intentionally because I was blank. No. Cut it at the first part. That's truth. This rest part is another lie. So you're sandwiching the truth between two lies, and they're both going to fall away until the only truth left is that you did it intentionally. The defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant has presented evidence of a justifiable use of deadly force. Perfect. I love that addition, because for the first one, it was Dr. Julie Harper can't respond to anything. She can't bring up battered spouse syndrome unless Sarah testifies to those facts, which then she can expand upon and explain. Now they're saying she can't even do that unless she presents evidence that justifies the use of deadly force in the situation she was in, not in any other point in time, in the moment in time when she filmed him. What evidence does she have to present that there was justifiable use of deadly force? She has none. So that should knock out both right then and there. And they are making sure that she can't bring it up in her opening statement, because she absolutely would. They absolutely would get up there and say, yes, this happened. This was a horrible accident, but what you're going to hear is that she was a battered spouse. Now these are saying she can't do that. She has to build that foundation first and then able to bring it up. That's what emotion and lemonade means. It's like, I am excluding this part of evidence or these types of statements until, maybe something else happens that can open those statements back up. But yeah, she is not allowed to mention this, or she will not be allowed to mention this unless certain specific qualifications and standards are met. And then she opens the door to run this defense, which then the state opens the door to shoot down. Which brings us to 7. Finally, the state requests the defendant be ordered to submit to an examination by an expert of the state's choosing. Yes, exactly. They already said they had one on the list that they were already ready to testify, but it's not even just good enough to get one doctor to agree to try to stretch the truth to say that this applies to her. That's already hard enough. Now she's going to have to sit down in front of a state's expert and run her story and put on her performance just for the state's expert to completely eviscerate that and to say, all of this is bull for XYZ reasons. So it's always going to be a battle of the experts, and normally the one who is more charismatic and easier to understand prevails, because juries like accessibility and not necessarily the over-the-top heavy jargon type of language. So hopefully these doctors don't get lost in the weeds. Whoever is able to really empathize and explain it the best, I think, will be the most persuasive to the jury. Yeah. I certify that a copy hereof has been furnished to James Sullivan Owens. Oh, William Robert J, Mr. J. I wondered why I liked the spice. See, this is what I'm talking about. I thought Mr. J is more of the one. The more I'm going to give it to you, because he came in a little late. We have been dealing with Mr. Cacciatore on Zoom for many years now, and now we've started to see him in person because things are ramping up. And then Mr. J came out of nowhere, and so he wrote this. Very good job. I very much like this. So I think this is giving an indication on his style of things as well. And what is his title? Assistant State Attorney. Okay, so they're both Assistant State Attorneys. So far, I don't see why any of these motions and responses should not win. They're all very concise. I mean, they're also going against nothing, right? There's no actual viable arguments that the defense has been able to put forth in anything. It's been a struggle just to submit things timely and as an actual work product. So this is a little bit of punching down, but not really. This is just clean lawyering. Good job. Next, notice of provision of state's amended witness list. Okay. I'm guessing this is just because if she's going to rely on this defense, now they have to officially put their witnesses on record of who they're going to call to disprove that. Because they also could call character witnesses for this, of people, if they're going to say that this happened regularly and that everyone saw, let's put everyone on the stand and say, what did you see? And they're going to say they saw both of them going at it with each other. They're also going to say they saw Sarah being the more aggressive one. Or at least that's what every single person has said so far. Yeah, pretty much. And by aggressive, maybe not the strongest, but as in the biggest personality with the biggest actions behind them. We'll put it that way. Comes now the state of Florida by and through the undersigned Assistant State Attorney, and files this notice of provision of amended witness list, certifying that on the date of filing the instant notice of provision of amended witness list, the undersigned Assistant State Attorney electronically served upon the defendant an amended list of names and addresses of persons known to the state to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact evidence to be presented at trial under section Florida statutes that were discovered subsequent to compliance with rule I certified Dave Cacciatore. So I feel like Mr. J might be the lead one on this, because it seems like he took on the harder motion, and there's like 3-in-1 motions. And then Mr. Cacciatore has had all of these other motions. And then this one, notice of provision of discovery, comes now the state of Florida by and through the undersigned Assistant State Attorney, and gives notice to the below listed exhibits have been disclosed to James Owens and Kevin T. Beck. I knew she got a new lawyer. I did not know the name, and I have not researched them much. But Kevin T. Beck, Owens and Beck, Beck and Owens. Okay, this is the crew that will be going up against Mr. Cacciatore and Jay. All right, in this corner, we have David Cacciatore and Mr. J. No, what are we doing here? And yeah, I guess James Owens and Mr. Beck are getting... Hold up, pause everything. As I'm editing this video, everything always happens. Nothing ever stops here. So there has been a new third act character come in. There is another lawyer. His name is Tony Henderson. I know nothing about him. Don't really care, honestly. But it is not just Mr. Owens and Mr. Beck. Now it's Owens, Beck, Henderson. Hopefully Jesus will join next. Maybe that will actually help you. I don't know. I doubt it. But yeah, they have another lawyer, because of course they do. They have a third lawyer. She went from having 8 court-appointed lawyers, complaining to get rid of all of them. Absolutely terrible behavior, just a very rude individual to people who were hired to help her. And as a reward for her bad and awful behavior, she now has 3 lawyers. 3 very experienced lawyers using a lot of their resources and time away from their other clients to help Miss Paulson. I've said it so many times, she gets absolutely everything she wants, given the circumstances. Absolutely everything. She is on trial for second-degree murder, for zipping someone in a suitcase. That is so clear-cut, yet she has extended this to over 4.5 years. And that was intentionally done as well. Every extension that's happened has been intentionally done as well. And she still succeeded on top of that. She has more legal resources than she ever would have had if she acted appropriately and just took court-appointed counsel. So other people, take a note out there. If you want this kind of treatment, make the biggest scene the world has ever seen and just be relentless about how difficult you can be. And then you too can have 3 very professional lawyers drop everything they need to do to come help you go to prison. Yeah. I mean, I'm not mad at it. I get it. I understand it. You have to pull off a defense in 30 days. You need to tag in some friends. They're here to help. I get that, and I can respect that. However, when zooming out, it's like, of course. Because why not? Why not? And you know what? I know it's not just going to be a third. There will be a fourth. Mr. Owens will have to start rejecting people at this rate with the amount of people they pull in. And what is it going to be for? Truly, what it's going to be for is to put that family through hell even more. Is to have more people try to rip into the Torres family to ruin credibility and to make it seem like it's his fault this happened to him. And they have to. Like, that's their job. Their job is to sow doubt into every single witness. So every single one of George's family members will now have 3 lawyers coming after them instead of 1. Yet she complains that everything to this day is not fair for her. Oh well, that's neither here nor there. Good luck. I do not think it'll really change the outcome. It's just the principle of the matter. And yeah, good for her. Keep it up. I haven't seen a letter from you, Miss Paulson, in a little while, so I will be on the lookout for that. Do not disappoint. You haven't thus far, so I expect this same behavior. Of course, there's another lawyer. Congrats. Welcome to the circus. The following have been sent electronically on September 11th, 2024. Previous deposition transcripts. Okay. More transcripts. More transcripts that they already have. Yeah, it says previous deposition transcripts, meaning we've done this, we've sent this, you have this, take it again. But it is what it is. And that's why on these other ones that Mr. Cacciatore brought up the due diligence argument of they're already going above and beyond and giving them so many extra things that they've already given them. And they're doing that because, oh, it's just easier to just give it to them because that's what Sarah does. She wears people down to where it is just easier to give her what she wants and get her out of your hair. But that is not always fair, nor is that fair for everyone else who has to adjust themselves to give her these things multiple times. So some things, yeah, if I can just send it to you in an email, great. If you want me to give you 7 million USBs that you will then complain about later, go away. Google is your friend. Look, y'all need to be hitting up ChatGPT. I feel like this could have helped her the most. That's what she should have done with that third-party friend that she had. She should have said, can you put this in here and tell me what I'm supposed to do? It wouldn't have helped that much, but it would at least make it sound better. But yeah, so it looks like the state is not going to back down. Like I mentioned before, the gloves are coming off. They do not have to hold back anymore because she is no longer pro se. And Miss Paulson will be torn apart by her own life or by the things she's done in her life. And this might be the first time in her life she will have to sit down and actually hear about her actions in depth. This will be an intervention, and the intervention will result in prison. And I've heard some people, here and there wonder, is she really worth that? Shouldn't she just get like 10 years, 14 years here, 20 years here? No, she shouldn't. It should be a life sentence. I get it. She has grown on people as a personality. The crime is something of nightmares, nightmare fuel, and something that should be discouraged and made an example of. You do not do this. You do not attempt this. You do not get off laughing and joking at someone suffocating in a suitcase, and then you just get a slap on the wrist just because you're annoying and wore people down. No. I have no doubt in my mind that this will be a life sentence. She can try to appeal it. I think her best outcome of this is life with parole. I think life without parole is an option. It really is. And it's a feasible option. People may think she's not dangerous. She absolutely is. We see how easily she gets aggressive. If she was not in chains all this time, she would have absolutely gotten up yelling and screaming. She had to get pulled out of the court by her shirt because he told her she doesn't have a lawyer anymore. If she was not chained up, I'm sure she would have jumped across the table. And we even see in the interrogation how quickly she is able to yell at police officers with guns in her face. So no, I do not trust her out in the streets just because she uses that little age regression whiny voice. And the fact that she still does not think she did anything wrong, she doesn't. She has not apologized once. That's the wild thing. She has not apologized once for anything involving the crime. Anything. She doesn't think they drank too much. She doesn't think they argued. She thinks they were just having a great day. I mean, she doesn't think that. She is telling us they were just having a great day. Everything amazing. And then I just went to sleep. I don't know what happened. And she's been holding on to that story for years, and she can hold on to it for many more years in a cell. In a cramped cell that she's going to feel is claustrophobic. And the fact that in one of those hearings when she rejected the cell that they got for her because she's like, I don't ever want to be confined in that or something like that.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to Orange County Corrections Department, and if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified, and nonetheless, I'm behind a closed door for 24 hours.
It's just the irony, and I don't even know what you call it, a word above that is just deplorable irony. And we saw this in the Shonda Vander Ark case with both Paul Ferguson and Shonda Vander Ark. At the end of Paul Ferguson's interrogation, which made me so upset, I was fuming. He asks for a snack because he's like, oh, I have low blood sugar, this or something, whatever. Can I have a snack? I'm like, sir, we have just been talking to you for over 2 hours about why you tortured and starved your brother to death. And you have the nerve to ask for a snack? No. And then Shonda on the stand was like, people don't understand. I was so stressed. I just kept blacking out. I don't know what happened. I haven't even eaten in jail for like a month. I mean, like, I was so crazy. I just haven't even eaten. I'm like, again, you were on trial for starving and torturing your child to death. And you want us to care that you haven't eaten? What? Sarah Paulson wants us to care that she's claustrophobic, that she gets cramped. I don't. You're alive. And they will let you out of that cell each and every day. So you must deal with your actions. I know you think it's unfair. You think it's da-da-da-da, that this happened so long ago. He spent the rest of his life in that suitcase. And you can spend the rest of your life in a cell. Anyway, I think that's that on that. I don't know how long this is going to be. It might be pretty quick, but yeah, I'll try to get this up by tomorrow and get working on my next video. So yeah, thank you all again. If you have any questions, let me know. I'll try to answer some in the comments. Oh wait, I wanted to give an update on the whole members thing. So I like to split the difference. I did start a little membership option. It is $1.99 a month and you get your badge, and it's just the slight early access to my videos, as in I will upload them immediately when I finish, and then I will have a more scheduled premiere for, you know, just in general. But yeah, so there's no big deal. I'm just being upfront. I don't have any overwhelmingly special things planned. If something comes up, I'll do it. If not, you know, I love you all. If you stay, you stay. If you don't, you don't. I'll just reiterate, this channel is not about money, nor is it about any other ulterior motives besides getting out my opinions and just, yeah, having a good time with you all. So, thank you so much. And with that, don't forget to comment, like, subscribe, dislike if you're feeling it. Until next time.